What happens when a lifetime of calculated risks and monumental success is dismantled by a single sentence hidden in a sea of legal jargon? Can a man truly control his empire from beyond the grave, or does the very instrument designed to protect his family become the weapon that destroys them? If you had spent 40 years building a dynasty, would you ever imagine that 3 lines of text on page 48 could turn your children into enemies and your life's work into a cautionary tale? Today, we are pulling back the curtain on the haunting case of the Sterling estate, a billion-dollar empire that collapsed not because of a market crash or a bad investment, but because of a catastrophic oversight known only as Paragraph 9. This is a story of meticulous planning meeting human fallibility, and I promise you, by the end of this narrative, you will understand a profound and surprising lesson about the true nature of power and the terrifying fragility of a legacy. Welcome to Legal Wins USA. We bring you powerful stories and legal cases just like this one, insightful narratives designed to empower and inform you. Don't forget to subscribe for more. The story begins in the sterile, mahogany-clad offices of a top-tier Manhattan law firm where the air usually smells of expensive stationery and silent authority. It was here that the late Arthur Sterling, a titan of industrial real estate, sat a decade ago to finalize his last will and testament. Arthur was a man of absolute precision. He didn't believe in luck, he believed in leverage. His portfolio spanned across the tri-state area, a glittering collection of skyscrapers and logistics hubs that generated more revenue in a single quarter than most small cities see in a decade. He was the quintessential self-made man, a figure of stoic resolve who had survived 3 recessions and countless litigation battles. To the outside world, his succession plan was a masterpiece of legal architecture. He had established an irrevocable trust, appointed the most prestigious fiduciaries, and set up a complex web of shell companies to minimize estate tax exposure. He thought he had built a fortress that no one, not even the Internal Revenue Service, could breach. But the problem with fortresses is that they are often built to withstand an external siege while remaining completely vulnerable to a rot from within. When the heart stops, the clock starts. Within 48 hours of Arthur's passing, the silence of mourning was replaced by the frantic shuffling of paper. His 3 heirs, each more ambitious than the last, gathered in that same mahogany office, expecting a seamless transition of power. They were prepared for the grief, and they were certainly prepared for the wealth. What they were not prepared for was the impossible problem that surfaced during the initial probate filing. A junior associate, tasked with cross-referencing the trust bylaws with the primary will, noticed a discrepancy in a section titled Miscellaneous Provisions. It was a section most lawyers glance over, filled with boilerplate language about governing law and severability. But nestled between a clause about arbitration and a paragraph about digital assets was Paragraph 9. It was a conditional trigger, a sleeper cell of a clause that contradicted the core distribution logic of the entire estate. It didn't just complicate the inheritance, it effectively froze every dollar, every property, and every share of the Sterling Empire. In an instant, a billion-dollar legacy was trapped in a legal vacuum where no one had the authority to move and everyone had a reason to sue. To understand the magnitude of the collapse, one must first understand the man who carved this empire out of the post-war industrial landscape. Arthur Sterling did not inherit a cent. He was the son of a shipping clerk from New Jersey, a man who viewed the world through the lens of scarcity and competition. In the mid-1970s, while his peers were chasing the trends of the era, Arthur was quietly acquiring undervalued warehouses and dilapidated pier spaces. He possessed a preternatural ability to see the future of logistics long before the term supply chain became a household phrase. By the time he reached his 50s, he wasn't just a landlord, he was a gatekeeper of commerce. His wealth was not merely a collection of bank accounts, it was a sprawling, living organism of commercial real estate, private equity, and offshore holdings. He lived by a singular, cold philosophy: emotion is a liability, and clarity is the ultimate currency. This was a man who demanded a fiduciary duty from everyone around him that bordered on the religious. He expected his family to function like his board of directors, efficient, loyal, and subordinate to the mission of the Sterling name. The heirs were a study in the different ways extreme wealth can shape a human soul. There was Julian, the eldest, a Harvard-educated shark who had spent 20 years in the shadow of his father's office, waiting for the keys to the kingdom. He saw the estate as a platform for global expansion, a vehicle for his own ego to finally outshine his father's shadow. Then there was Claire, a sophisticated philanthropist who managed the family's charitable foundations with a velvet glove that hid a hand of iron. She viewed the legacy as a moral responsibility, one that required preservation at all costs, even if it meant sidelining her brothers. Finally, there was Marcus, the youngest and the wild card. Marcus was the darling of the Manhattan social scene, a man who treated the family fortune like an infinite credit card. He had no interest in the logistics of shipping or the nuances of property management, but he had a very keen interest in the liquidity that the estate provided. Under the surface of their polished public personas, a cold war had been brewing for decades. Arthur knew this. He sensed the fracture lines in his family, and he believed that through the sheer force of legal engineering, he could prevent the inevitable explosion. The origin of paragraph 9 dates back to a late-night session during a period of intense personal crisis for Arthur. He was approaching 70, facing a health scare that he kept hidden from his children, and feeling the sudden crushing weight of his mortality. He began to obsess over the idea of a legacy that could outlive the selfishness of his heirs. He summoned his senior counsel, a man who had been with him since his first warehouse purchase, and demanded a clause that would act as a failsafe. He wanted a mechanism that would punish any heir who attempted to challenge the long-term integrity of the trust. It was meant to be a deterrent, a legal poison pill. However, in the frantic drafting process, amidst the pressure of a looming surgery and the complex layering of tax-sheltered entities, the language became mangled. What Arthur intended as a shield for his empire was drafted in a way that effectively turned the estate into a locked room with no key. The very wealth he spent a lifetime accumulating was about to be strangled by the very words he chose to protect it. The discovery of paragraph 9 did not happen with a bang, but with a chilling silence that filled the boardroom of the family's estate office. It was a Monday morning, less than a month after the funeral, and the siblings had gathered to sign what they believed were the final transfer documents. Instead, the lead executor, a man whose face had turned the color of parchment, placed a single page in front of them. The paragraph was buried deep within the fine print of the trust's restrictive covenants. On the surface, it appeared to be a standard spendthrift provision designed to protect the assets from creditors, but the second sentence contained a devastating syntactical error. It stated that in the event of any technical ambiguity regarding the distribution of a subtrust, all management powers of the trustees would be immediately suspended until a unanimous judicial declaratory judgment was reached across every jurisdiction where assets were held. In the world of Tier 1 finance, this was the equivalent of a nuclear meltdown. Because Arthur had diversified his holdings across the United States, the Cayman Islands, and Luxembourg, the clause effectively mandated a global legal stalemate. The secret clause was a masterpiece of accidental sabotage. It created a paradox. The heirs could not access the funds to pay the very lawyers needed to resolve the ambiguity, because the clause had frozen the accounts used for estate administration. Julian was the first to realize the implications. His face contorted as he realized that the hundreds of millions in commercial paper he was planning to roll over would now default because no one had the signatory authority to move the money. The irrevocable trust, which was supposed to be the family's greatest tax shield, had become an unbreakable cage. The fiduciary duty of the bank was now to do nothing. They were legally obligated to paralyze. This wasn't just a delay, it was a catastrophic liquidity event. The sterling empire, built on the steady flow of cash and the ironclad nature of contracts, was now hemorrhaging value by the hour. The irony was suffocating. Arthur's obsession with control had led him to sign a document that stripped everyone, including his hand-picked executors, of any control whatsoever. As the realization sank in, the boardroom transformed from a place of business into a theater of war. Claire immediately accused Julian of knowing about the clause and attempting to manipulate the drafting years prior to edge her out. Marcus, realizing his lifestyle was about to be severed at the root, began spiraling into a panic, threatening to sue the law firm for malpractice before the body was even cold. The first legal twist had arrived, and it was a bitter one. The siblings, who had spent their lives competing for their father's approval, were now forced into a shotgun marriage of legal necessity. They had to cooperate to break the clause, but every move one made was viewed with intense suspicion by the others. They were trapped in a classic prisoner's dilemma involving $1 billion. If they fought, the legal fees and interest on defaulted loans would eat the estate alive. If they settled, they would have to trust each other, something they had never been taught to do. Paragraph 9 had effectively resurrected Arthur Sterling's ghost, forcing his children to play one last cruel game where the only way to win was to lose their sense of autonomy. The peace that Arthur Sterling had hoped to buy with his billions vanished as the first lawsuits were filed not against the estate, but between the siblings themselves. By the third month of the freeze, the tension had reached a breaking point. Julian, desperate to maintain his standing in the private equity world, attempted a back-channel maneuver to have himself declared the sole managing director of the primary holding company, arguing that paragraph 9 only applied to the personal distributions and not the corporate operations. It was a bold, aggressive play that might have worked if Claire hadn't been 3 steps ahead of him. She used her influence within the family's charitable arm to freeze the voting shares held by the foundation, effectively neutralizing Julian's coup. The betrayal was absolute. The siblings were no longer talking, they were communicating through aggressive memorandums and third-party intermediaries. The emotional architecture of the family, already brittle from years of Arthur's coldness, shattered completely under the weight of the frozen assets. The conflict moved from the boardroom to the courtroom, and with it, the family's dirty laundry began to spill into the public record. Every deposition became a venue for airing grievances that dated back to childhood. Marcus, feeling abandoned by his older siblings, turned into a star witness for the very creditors who were now circling the estate like vultures. He leaked documents suggesting that the ambiguity in paragraph 9 wasn't an accident at all, but a deliberate attempt by Arthur to punish his children for their perceived weaknesses. This narrative of a vengeful father reaching out from the grave captured the imagination of the financial press. The Sterling name, once synonymous with stability and prestige, was now a headline for dysfunction. The psychological toll was evident. Julian's health began to fail under the stress of mounting personal deaths, and Claire found herself isolated, her reputation in the philanthropic world tarnished by the scorched earth tactics of her brothers. At the peak of the conflict, a discovery was made in Arthur's private safe that added a layer of Shakespearean tragedy to the betrayal. It was a series of handwritten letters, never sent, addressed to each of his children. In them, the titan of industry revealed a man terrified of his own success. He wrote about the loneliness of the summit and his fear that his wealth had acted as a barrier to the very love he wanted to provide. He explicitly mentioned the drafting of the trust, explaining that he wanted to create a system where they would be forced to work together, a final lesson in solidarity. But the letters also revealed the exhaustion of his final days. He admitted he hadn't fully read the final version of the documents, trusting his counsel implicitly because he was too tired to fight the legalese any longer. The betrayal wasn't malicious, it was a betrayal of negligence. The man who demanded perfection from the world had succumbed to the most human of errors, fatigue. This revelation did nothing to stop the war. Instead, it fueled the fire, as each sibling interpreted the letters as proof that they were the true favorite, further entrenching their positions in a battle that was now costing the estate $500,000 a week in legal fees. The final showdown took place in a windowless courtroom in Lower Manhattan, where a seasoned probate judge looked down at a mountain of filings that represented the slow-motion suicide of a billion-dollar empire. The air was heavy with the scent of old paper and the palpable animosity radiating from the 3 siblings, seated as far apart as the gallery would allow. The resolution did not come through a brilliant legal argument or a moment of familial reconciliation, but through the cold, hard reality of a looming deadline. A major debt facility tied to the crown jewel of the Sterling portfolio, a 60-story glass tower in the financial district, was set to mature. Without a signature from a unified board of trustees, the bank was prepared to foreclose, an event that would trigger a cross-default clause across the entire global portfolio. The estate wasn't just at risk of being diminished, it was on the verge of total annihilation. The judge, sensing the gravity of the moment, issued a rare ultimatum. The siblings had 48 hours to produce a settlement, or he would appoint a third-party receiver to liquidate the entire legacy at pennies on the dollar. Faced with the prospect of losing everything, the heirs were finally forced into a room without their lawyers. For 12 hours, the silence of the Sterling mansion was broken only by the sound of bitter negotiations and the ghosts of their shared past. The verdict was a grim compromise. To bypass the catastrophic ambiguity of paragraph 9, the siblings agreed to dissolve the irrevocable trust entirely, a move that triggered a massive immediate estate tax bill that Arthur had spent 40 years trying to avoid. The government, it seemed, would be the largest beneficiary of the Sterling fortune. They had to sell off nearly 40% of their father's properties in a fire sale to cover the IRS demands and the mountain of legal fees that had accumulated. The court finally signed off on the distribution, but the empire that emerged was a shadow of its former self. Julian received a collection of secondary assets, but lost his seat on the boards that gave him power. Claire's foundations were stripped of their primary funding, and Marcus received a lump sum that was significantly smaller than the debts he had accrued during the litigation. The final outcome was a masterclass in the unintended consequences of legal over-engineering. The Sterling legacy was not destroyed by a competitor or a market shift. It was dismantled by the very mechanisms meant to preserve it. When the dust settled, the siblings went their separate ways, bound by a settlement agreement that prohibited them from speaking to each other for a decade. The glass tower was sold to an overseas sovereign wealth fund, and the Sterling name was scrubbed from its lobby. The court's final decree was a cold epitaph to a man who thought he could control the future with a pen. Arthur Sterling's life work had been pulverized by a single, poorly drafted paragraph, proving that in the world of high-stakes inheritance, the most dangerous weapon isn't greed or malice, it is a typo buried in the fine print. The fortress had fallen, and the only thing left was a collection of fractured lives and a legal precedent that would be studied by law students for generations to come. The ruins of the Sterling Empire offer a chilling masterclass in the psychology of wealth and the limitations of law. We often view a legacy as a physical monument, a building, a brand, or a massive bank balance, but the true legacy of Arthur Sterling was the silence that followed the final gavel. The evergreen lesson here is one of humility over hubris. No matter how many layers of protection you build, no matter how many irrevocable trusts you establish, the ultimate success of an estate plan does not rest on the complexity of the documents, but on the clarity of the intent and the health of the relationships it leaves behind. Paragraph 9 was a symptom of a deeper disease, the belief that legal structures can replace human trust. Arthur spent millions trying to legislate the behavior of his children, forgetting that a document is only as strong as the people tasked with reading it. When you remove the human element from the equation of inheritance, you don't create stability. You create a void that the law will ruthlessly fill with its own cold logic. The karma of the Sterling case is particularly poignant when we look at the final destination of the family's wealth. The very tax shelters Arthur obsessed over eventually became the catalysts for the estate's depletion. In his frantic attempt to avoid paying a fair share to the society that allowed him to prosper, he created a trap that cost his family far more than any tax rate ever could. There is a profound irony in the fact that the most sophisticated estate planning in the world can be undone by the simplest of human errors, a lack of communication, and a failure to review the work of those we trust. For those watching who are building their own legacies, the takeaway is clear. Transparency is the only true shield against litigation. A legacy is not something you impose on your heirs, it is something you build with them. If your plan requires 1,000 pages of restrictions to keep your family from tearing each other apart, the problem isn't the law, it's the foundation of the family itself. As we close the file on the hidden clause that destroyed a billionaire, we are reminded that true wealth is the ability to walk away from the table with your dignity and your kin intact. The Sterling story ends not with a bang of a gavel, but with the quiet realization that a lifetime of work was erased by 30 words in a forgotten section of a document. It is a reminder that in the high-stakes game of global finance, the most valuable asset you can ever leave behind is a clear path forward. Arthur Sterling's name may have been removed from the skyline, but his failure remains a permanent fixture in the annals of legal history, a warning to every titan that their greatest enemy isn't the competitor across the street, but the paragraph they didn't read.